Well, we're here today with Professor Scott Phillips, the University of Denver, Department of Sociology and Criminology. Professor Phillips has done some very important work with respect to the death penalty, examining multiple issues, largely focusing on how the death penalty has been administered. He's the co-author of some very prominent publications earlier this year, one in the Columbia Human Rights Law Review, and the other one, and the one I'd like to begin the discussion with, was published in the Harvard Civil Rights, Civil Liberties Law Review. It was the principal article in the issue. Other authors were invited to comment on it. It was noted, I believe, in the New York Times, so it's got all the earmarks of a very important landmark study. And Scott, if you can kind of walk us through first, I mean, your study examined the death penalty in Georgia. And it's no accident, I think, that the Supreme Court's history of death penalty jurisprudence in the modern era begins in Georgia with Furman and progresses to Gregg versus Georgia, and then McCleskey versus Kemp, another Georgia case. So could you start us with some of the assumptions underlying the court's decision in Furman, and then Gregg, and what it did in McCleskey, and how your research ties into all that?
Sure. So thanks for the very nice and generous introduction. I just want to start by saying that if Justin Marceau and I were able to accomplish something good, it's because we were building on the work of David Baldus, who did an extraordinary study. And our work simply follows up using his data, but extending it. So we're really sort of standing on the shoulders of a giant in the field. And as your listeners may know, Baldus studied the death penalty in Georgia. The Supreme Court had said in Furman that the death penalty was imposed arbitrarily. Some justices thought it was imposed randomly. Others thought it was patterned by facts that shouldn't matter, like race and social class. And the death penalty was struck down. States brought it back. 35 states wrote a new law between 1972 and 1976. Gregg versus Georgia, 1976, the new laws are, the guided discretion laws are declared constitutional. The mandatory death laws are declared unconstitutional. And that very, very brief summary gets us to McCleskey. And in McCleskey, the key question is, did the new rules and procedures work? Did the new rules and procedures eliminate the arbitrary character of the death penalty that concerned the justices in Furman? And Baldus' study showed quite clearly that defendants who killed a white victim were more likely to be sentenced to death, much more likely. And that held true even after controlling for confounding variables that might confuse us if we didn't take them into account. The Supreme Court hears the case and concludes that it doesn't rise to the level of a constitutional violation because patterns across thousands of cases can't be used to determine whether McCleskey himself was the victim of discrimination. And the court is also worried about a slippery slope. So Justin and I decided that nobody had ever followed up on Baldus's work. And we wanted to know what happened next. So we know that those who killed a white victim were more likely to be sent to death row. Among the defendants in the Baldus data who were sent to death row were those who killed a white victim also more likely to be executed? And the answer is yes, which means that the racial disparities that Baldus found in the penultimate stage of the case, death sentences, were exacerbated in the ultimate stage of the case, executions. And those findings also hold up after controlling for confounding variables. So the bottom line is Baldus found racial disparities. He couldn't have known what would unfold over the next 30 to 40 years. It turns out that things got worse?
Well, that's beyond ironic. It's discouraging because one of the assumptions, I think, built into the Supreme Court's jurisprudence was that the guided discretion statutes would go a considerable way in alleviating the arbitrariness. Of course, as you noted in McCleskey, the court had evidence at its disposal, chose not to go where the evidence would take it. And your study suggests that the court system itself, or at least in Georgia, is not adequate to capture any of the residual arbitrariness, racial disparities that take place at the sentencing phase. Is what you found in Georgia, I know you've done other studies, is it isolated to Georgia, or does it seem to be endemic to other systems that you've looked at or others have looked at?
Yeah, that's a great question. One quick comment about the Georgia data, and then I'll say something about the other states. Justin Marceau and I are now looking, along with other co-authors, at what happened in the appellate stage of the Baldus cases in Georgia. And often, the death sentence was overturned on appeal. The question is, would the prosecutor seek death yet again before a new jury? And that was more likely to happen if the victim was white, especially if the victim was a white female. And as we are working on the current project, we are beginning to see that the next stage of the case, although of course the appellate courts are critical, also comes down to the same actors as before. If a sentence is overturned, the prosecutor decides to go for the death penalty yet again. If the prosecutor decides to go for the death penalty yet again, the jury decides whether to impose a death sentence. So the next stage involves many of the same actors that produced disparities at the prior stage. So that's a project we're working on now. And it's a challenging project to follow cases through the appellate system, but we're doing our best to track down all the records, and we hope to write something up about that soon. But many of the same actors are involved even after the initial death sentence. The prosecutors, the juries are involved in addition to the appellate courts. So, yeah. So the other question you had asked was about other states. And my colleague Tate Steidley and I published a paper about the Texas death penalty over the summer. And what we found was that there were many, many people in Texas who could have been sentenced to death from the 1970s to the present. Only about 1,000 of them were. There were about 9,000 who could have been sentenced to death. About 1,000 of them were. And if you had killed a white woman, you were far more likely to find yourself on Texas death row. So it was both arbitrary in the sense of random, the issue that concerned some of the Supreme Court justices in Furman, but it was also arbitrary in the sense of patterned, that the social characteristics of the victim really mattered.
Well, let's tap a bit of your sociological expertise. You've documented in the studies what seems to be happening, and the what involves patterns that are either very difficult to explain because they're so haphazard, or that they relate to systematically relate to demographic characteristics, race, gender. The sociological question, I guess, would be maybe it's an obvious one, but why? Why are we seeing, in your view, these disparities in the way that the death penalty is carried out?
Well, I think the answer is that the death penalty is just a microcosm of broader society. It's not special in a sense. It is a reflection of broader historical trends and problems that we've never fully addressed in the United States. And, as your listeners know, some victims seem to, quote, matter more than others. The death of a white woman, especially a high-status white woman, tends to send the system into overdrive. The death penalty is really overdrive for the system. And one way that I've thought about this is a death penalty case is an enormous amount of work. It's not simply going to be settled with a plea bargain. It's going to be two trials, really, a penalty trial after the guilt trial. It's going to be years of work in the appellate system to defend that conviction and defend that death sentence. And whose life and death is worthy of that additional effort? And the research says it's the life of a white victim, especially a white woman, and especially a high status victim. So I think the answer to the question is, if we, many of us are very interested in the death penalty, we read about it, we study it, but really it's just one aspect of a much broader set of circumstances in society.
And one might be tempted to conclude that legal rules are inadequate to harness some of the broader sociological elements. I think you're quite right in that sometimes we forget that the criminal justice system is immersed in a much larger social context, and it's certainly not immune from the forces that exist in broader society. Do you have any sense, Scott, of whether legal rules could help minimize some of the untoward effects that are popping out in the punishment system, especially in the death penalty system?
Well, if there were a set of legal rules that would solve the problem, we haven't found them yet. And it could be that we just haven't thought of the right solution. But I don't know that truly exists because even, for example, looking at historical lynching data, many, if not most, lynchings occurred because someone harmed, or allegedly harmed, of course, we don't know what really happened, allegedly harmed a white person, especially a white woman. So this is nothing new, and it seems to me that we're dealing with something that would overwhelm whatever legal rule is put in place. For example, we could have gone with a mandatory death penalty. And in one sense, that might have solved the problem. Anyone who commits a crime on a particular list gets the death penalty, but what crimes go on the list? If the crimes that go on the list are the ones that are more often committed by certain defendants or more often committed against particular types of victims, then you actually still have racial disparities, even if the death penalty is mandatory, because the subset of crimes that qualify for mandatory death may themselves be infused with racial dynamics. So, we rejected mandatory death. It might not have solved the problem anyway. Guided discretion certainly hasn't solved the problem. I don't know what the legal rule would be that would be sufficient to overcome what is, a much broader social phenomenon.
Well, one of the very important contributions of research of the type that you're doing is to kind of disabuse us of the notion that the assumptions that are made in law do not always pan out in reality. So I think it's critically important that research of the kind you're doing continues to be done in order for us all to examine whether the assumptions the law makes are credible. Where are you going with your future research plans? Have you anything definite? You mentioned something briefly, but any other jurisdictions or strategies you're pursuing?
Yeah, as I mentioned, we're trying to pursue the Baldus data one step further to really dig into what happened in those cases during the appellate stages. I'm also looking closely again at the Texas death penalty. There's been a fair amount written about the Texas death penalty, but perhaps not as much as one would expect given the role of Texas in the national scene. Clearly Texas has executed more than any other state, and by a really wide margin. So I'd like to keep working on both those projects. Another project I'm working on is, I published a paper with a student a couple of years ago, and we relied on data from the National Registry of Exonerations. And we were able to show that as the seriousness of the crime increased, as the crimes got increasingly egregious, the number of faulty forms of evidence in the case also increased. And the reason I think that's important is because we know, of course, that innocent people go to death row and are executed. But this research, I think, takes that logic a step further and says, it's not just that innocent people go to death row and are executed, it's also that the kinds of cases that many people feel are ripe for the death penalty, the most extreme cases, also seem to generate the worst evidence. And the title of that paper was "The Worst of the Worst, Heinous Crimes and Erroneous Evidence." And if that's true, if what we found really is true, then the most severe cases are particularly susceptible to the worst forms of evidence. Those cases were more likely to have a false confession. You can imagine that the worse the crime gets, the more detectives push in the interrogation room. Those cases were more likely to rely on a snitch. You can imagine that the worse the case gets, the more the police are willing to put a snitch on the stand. Those cases were more likely to have government misconduct, such as a Brady violation. You can imagine that the worse the case gets, the more that corners might get cut. So I'm interested in this line of work because it says more than just we send innocent people to death row. It says the worst cases might actually be the most likely to result in a wrongful conviction.
Well, that'll be another fascinating study, and it's so important to keep studies of this sort going. As you know, we have the National Death Penalty Archive here in Albany. And as you know, again, we have, with respect to innocence, some of the work that Mike Radlett and Hugo Bedeau did in their classic examination of wrongful convictions in capital cases in the 20th century. We have David Baldus's papers, many of them in the archive, and some great day, I'm sure historians will be looking back on the work you've been doing, Scott, because it's so very important.
Well, thanks. And I want to, before we close, I just want to send a thank you to Jody Boyle, who's a librarian at the National Death Penalty Archive. So when Justin and I updated Baldus's research, the challenge was that the cases are anonymous. They just have a case number. And so we knew that 127 of those defendants had been given a death sentence, but we didn't know the names of those people. And so Jody was able to go through boxes and boxes and boxes of Baldus's materials and find a incredibly key piece of paper for us that matched the anonymous case number to the defendant's name. And that's what allowed us to then go into the records and find out who was executed and who wasn't in the Baldus study. So not only does the National Death Penalty Archive have amazing data, it also has amazing people who are very, very helpful. And so just a thank you to her and an encouragement to others to use all of the treasure trove of data that's available.
Well, let me quickly but enthusiastically second your endorsement of Jody Boyle. I've had a chance to work with her over the years, and she's nothing short of tremendous. Scott Phillips, thank you so much for sharing this information with us and talking about your research and where you're going next. And we'll look forward to future chances to read what you've been up to. And thanks again.
Thank you.